Yep, take it away, Chris.
All right, terrific. Hey, everybody. My name's Chris Austin. I am the Vice President of Client Management here at FullscopeRMS, and for better or worse, I am going to be your host for today's webinar entitled Solving the Top 10 Dilemmas of Absence Management. This is another webinar in the series that we've been doing for a bit to help keep you and yours updated on trends that could impact your business in the industry. So looking forward to this one today and the others in the future. So, as folks may be aware, absence management in the landscape has become increasingly complex for consultants, for brokers, and insurance companies to navigate. And working with employers on managing absences on all types of business today can be really confusing. With the ever-changing state of federal regulations, every day is a new adventure. So we're hoping by walking through some of these complex examples today, we can help build, or honestly, for a lot of you, supplement your knowledge and understanding in the absence market. So that's why we have with us today FullscopeRMS Counsel Sue Wood. For those of you who have not already gone to her LinkedIn or Googled her, because I know most of you probably already have, she's an experienced absence management compliance attorney, and she's going to help us understand and solve all these dilemmas today. So no pressure. We're going to discuss the Family and Medical Leave Act, and when it runs concurrently with other type of absences and benefits, how workplace accommodations factor into absence management, and the effects of the new state-mandated paid family medical leaves on employer policies. So a lot there in the next hour. We are going to be taking questions at the end, so please drop them in the Q&A. I'll be monitoring that, and I'll get back to them as many as time allow. If we do run out of time, we'll make sure we get your questions answered and back out to folks. The webinar is being recorded, and the slides and the presentation will be sent out to those folks who are on here as well. Following the webinar, we are going to ask for a couple minutes of your time with a brief survey that's going to appear in your browser. So if you could, please take a couple of minutes and provide us with your feedback. All right, so without further ado, I'm going to turn it over to Sue, who is going to lead us through our discussion on the top 10 dilemmas of absence management. Take it away.
Great. Thanks so much, Chris. I really appreciate it. And welcome to everybody. We really appreciate that you're joining us today. So let's go to the next slide where we're going to talk about integrated absence management. Essentially, why do you as insurance carriers, brokers, consultants need to know about absence management? Well, there's an increasing overlap between the type of group insured benefits that you may deal with on a daily basis and mandated leaves. In addition, there are more and more states passing paid family and medical leaves, which can often offer the same pay or types of percentage of wage replacement that some of your group insurance products also offer for overlapping reasons. Employers are really looking for an integrated management of both disability and absence and leaves for their employees. And so they're looking for integrated solutions, often with one provider, so that you can be a one-stop shop, so to speak. So there's a real opportunity out there for carriers and brokers who are well-versed in the topics of absence management to be able to talk to their clients and prospects about how they can help reduce administrative burdens, increase compliance in the absence area, shorten the duration of disability leaves for their employees, get them back to work quicker through robust return to work protocols, and really enhance the employee experience by having that kind of one-stop shop. And just knowing about your own products won't be enough anymore to satisfy this growing segment of the group benefit business that's looking for an integrated solution. In addition, a lot of the people that you deal with at the policyholder level, the employer level, are going to be the group benefits personnel or the HR people, and they're the same ones that are likely grappling with these complex absence issues. And so your knowledge on that and being a thought leader on that will help them find solutions and be able to integrate your solutions with their management processes. So let's take a look next at the next slide, which is a brief overview on the DMEC Leave Management Survey from 2020. Now, most of you probably know that DMEC is the Disability Management Employer Coalition, and they put out a survey every year on leave management topics where they're asking employers to provide actual data on how they manage their leaves and what that looks like. So in 2020, when they asked the question about how employers were managing regulatory leaves, and that includes federal FMLA, state medical and family leaves, as well as state and federal military and other state mandated leaves, you can see by the survey that for smaller employers, those with under 100 employees, fewer employers were outsourcing or looking for an external management of that regulatory leaves. They were doing them mostly in-house. However, as the size of the employer increases and those management, management tasks in the absence space become more complex, they're looking for more outsourced, externally managed solutions, which again is the opportunity that we're talking about for all of us in the industry today. Now that number goes even higher for employers who are either multi-state employers or in states where a paid Family and Medical Leave Act has been passed. So the next slide will show the statistics from that DMEC survey on what employers in these states where there has been a paid family and medical leave law passed, how many of them are outsourcing or looking for external management of their absence and their FMLA administration. And as you can see, the numbers jump dramatically. So you're in the 40 to 50, almost 50% range of employers in these states that are looking for outsourced solutions. In other words, as the integration of insured products and leaves becomes more complex and employers are challenged by the variety of leaves they have to administer and the overlap of these paid benefits, their desire to outsource and find these integrated solutions appears to be rising. And again, this is an opportunity for carriers and brokers alike. If you can understand these complexities and what an integrated solution can do for your clients, then it really can offer an opportunity for you to step in their shoes and offer the solutions that are going to make their lives easier and you to be a trusted partner for them. So today we're going to cover these major challenges that can arise in absence and how they intersect with insurance offerings, because the more that you know, the more you'll be able to speak with your clients about these solutions. So in the next section, if we go on to the next slide, we're going to briefly, like 2 or 3 minutes, talk about absence basics, because we're assuming you already know a lot of this. This is not just an FMLA 101 seminar. So we're going to talk about the basics very briefly. And then we'll move on to the challenges. So on the next slide is a brief overview. We've got the federal laws. As you well know, there aren't as many federal leave of absence and accommodation laws as there are on the state level. But the federal primary laws that most employers have to worry about, of course, depending on size, is the Family and Medical Leave Act, or FMLA, USERRA, which is the Uniform Services Employment and Reemployment Rights Act, which offers employees who are serving in the military the right to return to their prior employer. The Americans with Disabilities Act, or ADA, which prohibits employment discrimination on the basis of a disability. And not only does it prohibit discrimination, but it requires employers to look at offering reasonable accommodations to qualified disabled persons to do their essential functions of their job unless there's an undue hardship or direct threat. And finally, the PDA, that is the Pregnancy Discrimination Act, which is an amendment to Title VII, which is the primary anti-discrimination law on the federal level, and covers employers that are also subject to Title VII, which is 15 or more employees, and prohibits discrimination against pregnant employees and applicants on the basis of their pregnancy or related conditions. Now, on the state level, you well know there's a lot of states who have jumped on the bandwagon to pass paid family and medical leave, the PFML. It's a hot topic. It's something all of us have been monitoring quite a bit. And as you may be aware, there's 10 jurisdictions currently that have some type of mandated program on a paid family or medical leave basis, with New Hampshire being the next one that passed a law, but it is a voluntary program for private employers. So that's a new twist, which we're not going to get into today. But also on the state level, not only are these paid family and medical leave laws troublesome to employers, there are a myriad of other types of mandated leaves that apply to employees in certain states that can cover everything from being a crime victim to being a member of the Civil Air Patrol that requires leave, to voting leaves, and then of course pregnancy accommodations. And for pregnancy accommodation, many state laws do include leaves as a potential reasonable accommodation. On the local level, there's also municipal ordinances that have been passed that can cover paid leave, such as the San Francisco Paid Parental Leave Ordinance, which is a top-up of the California Paid Family Leave Law. And then there's also unpaid local laws like the Miami-Dade County Ordinance that offers an unpaid but FMLA-like type of leave that's job protected for employees in Miami-Dade County. So this is just a brief overview to show kind of the complexity that can appear on the multiple levels, federal, state, and local, that clients and employers might have to deal with. On the next slide, we talk about how that then intersects with a lot of benefits and protections that you, as a broker, consultant, or carrier, are either involved in offering or providing to your policyholders, or sometimes would be consulting on. And that includes workers' compensation. Obviously, if the employee is injured or becomes ill due to an on-the-job or employment-related reason, workers' compensation kicks in. You've got short-term disability policies. That is a big one where we've got a huge overlap, because often when someone qualifies under a short-term disability policy, it's going to also trigger a lot of numerous other leaves on both the federal and state level. There's company policies and leave benefits. For example, on a company level, the employer level, many employers are instituting programs or plans on their own that they fund themselves that may offer paid benefits, again, that intersect or overlap with some of these other mandated benefits, things like a paid parental leave program. I know my own employer offers a very generous paid parental leave program, and that offers 100% wage replacement for a certain number of weeks, and then drops down to a lower percentage for an additional period of time. So company policies like that then do get intersected with some of the other benefits that may apply based on the reason for that leave. There's one aspect of intersecting benefits and protections that we're not really going to get into, but you should be aware of, and that's the state paid sick leaves. A number of states have passed, and actual municipalities as well, have passed paid sick leave laws. And these are accrual-based requirements. In other words, the laws require covered employers in those states or municipalities to provide paid sick leave, and typically it's based on an accrual basis where, say, for every 30 hours worked, the employee accrues 1 hour of paid sick leave up to a certain cap. That is often for the employee's own health because of the sickness, but there can also be components under the state sick leaves that could trigger other uses that may also overlap and intersect with other benefits. And that can be what we call safe leaves. That's where the employee has been either a victim or involved with a domestic violence or some other perhaps sexual assault or something of that nature. And they need time off to either handle legal matters, to move and get a new residence, get new phone numbers and all of that sort of thing. That sort of safe leave can sometimes be included as a leave reason or a usage for paid sick leave under a state law. In addition, there's what we call kin care. Sometimes the state paid sick leave laws will allow employees to use their paid sick leave to care for a family member and not just for their own illness. And so there's so many different nuances to these state and local paid sick leave laws. And as I said, we're not really getting into those accrued laws today, but those are something you should be aware of as you are discussing with your policyholders and clients how they are able to approach absence management as a whole. So let's get into the dilemmas. We're going to look at, as the next slide says, the top 10, and these are very, admittedly, my subjective approach to selecting these top 10 based on the types of questions that I have seen through claims management, through employer questions, all of those sorts of things as to the type of challenges and the big picture concerns that your clients and your policyholders and such are going to face when they're dealing with these various absence management situations. So let's look next on the next slide to our absence dilemma number 10. Which state laws apply? So here's the scenario, right? You've gotten a policyholder, a client named Acme Corporation. They need help on determining what state laws on the leave side apply to them. They're headquartered in New York, but they have multiple offices throughout the United States. They have a few remote workers, and they got a couple of employees in Massachusetts. So what laws apply? That's often a tricky one for folks. Well, the solution, as we can see on the next slide, is most often you're going to use the employee's work state. So if the employee does report to an office, to a facility, a warehouse, a store, anything like that, you're going to use the state in which that employee is actually working. That seems easy enough. But what about for remote employees? Well, the FMLA regulations state that remote employees you should look to the state at which the employee's work is assigned from or to which they report. So in our example, you might have the remote employees for Acme Corporation reporting to someone at their headquarters in New York. Then the New York laws will apply to that remote employee. But what if that remote employee reports to a director who's in Tennessee? Then that remote employee, because they report to and get their work assigned from a director in Tennessee, is going to be subject to Tennessee leave laws. And the state of residence for where that remote employee for FMLA purposes is not going to be the controlling factor. One key thing to look at, what is a state where Acme is paying that employee's employment taxes, unemployment, where do they have their workers' comp coverage, all of that sort of thing. That is a real key data point that can help you to guide folks through what state leave laws and mandates they should be concerned with. Now, why did I include the question about the two, or the bullet point about the two Massachusetts employees? So I just wanted to point out that there are many laws like the Massachusetts Paid Family and Medical Leave laws where there is not any sort of length of service or a length of time that an employee needs to work in that state in order to be subject to the law. But Massachusetts law does have a financial eligibility requirement. In other words, an employee needs to make like $3,400 in Massachusetts to be covered there. And so what I want to stress to you is that an employee, just because they may be the lone person in a state with the PFML law, if they're not reporting up to another state, or something of that nature, the employer still needs to look at the eligibility requirements for those state laws to see if they meet those laws, because even for 1 or 2 employees, they may need to comply with the state program. Let's go on to dilemma number 9. And that is, when is an illness not just an illness? Well, here's a scenario. So your STD policyholder, company called UPX Delivery Service, they have a forklift driver named Frank who stepped on a rusty fishing hook while he was on vacation. His foot becomes infected, and then Frank turns feverish and delusional. Your client wants to know, can they use the definition of a covered disability in its STD policy to determine what leaves will apply to Frank? And as you can see on the next slide, this is really the dilemma between the battle of the definitions. So under the FMLA, the definition you need to be concerned about for an employee's own health is, do they have a serious health condition? That is defined in the FMLA regulations, and it's generally going to be a condition that involves either inpatient care or continuing treatment by a healthcare provider. Now, there are some exceptions to that in the FMLA. For example, certain conditions that are permanent or long-term may have a different requirement as far as how many multiple visits to a healthcare provider that employee needs to attend. Or, for example, pregnancy under a serious health condition under the FMLA could include things like severe morning sickness, for which the employee need not even seek healthcare coverage for or treatment from a healthcare provider. So it's very detailed as far as how these definitions are laid out in the FMLA regulations. So a serious health condition is what is going to be the determining factor as to whether Frank is entitled to FMLA leave. The STD policy, on the other hand, is going to be defined by the policy itself. So typically that's either when the employee is unable to work for a certain number of days, or they've lost a certain amount of earnings, and there may be exclusions, right? There may be exclusions for certain types of conditions or injuries or something of that nature, certain elective surgeries or whatever, something that may not be covered, but it's going to be dictated by the policy. So under this scenario, you don't want to tell the employer, your policyholder, to use the definition in your STD policy to cover all these other leaves, because that could result in the employee not receiving coverage under, say, the FMLA, when they would in fact meet the definition of a serious health condition. Now, interestingly, the ADA has a very expanded definition of disability. It's quite expanded since 2008, when there was an amendment to the ADA, but it typically is not going to cover temporary injuries or illnesses unless they're really limiting that employee's activities. So things like the flu or a broken arm, a concussion, things like that typically don't rise to the level of an ADA disability. But again, it has to be determined on a case-by-case basis, because if it's severe enough, it's possible it could be limiting that person's life activities and therefore be an ADA disability. The other factor is state laws each define their own leave laws as to what is covered under those laws differently. So some do mirror the serious health condition language from the FMLA, which can help to make things a little more manageable, but others do not, and they may include a different definition for when their state law applies. So you do need to take a look at the state laws that apply to each individual employee, such as Frank, to determine what leaves may all be applicable. So let's look at dilemma number 8. And that is ADA where leave is a reasonable accommodation. This is one that folks struggle with a lot, and that's because we're very accustomed to having a defined duration, right? So the FMLA is 12 weeks or 26 weeks for military service member caregiving. STD policies will have a defined duration. It's either, you've got 13 weeks or 26 weeks or something of that nature. We're very accustomed to those benefits having those specified durations. And when they're done, right? But say you've got your policyholder has a cancer patient named Carly. She's exhausted her 12 weeks of FMLA leave and her 13 weeks of concurrent STD. Can her employer require her to return to work? She's exhausted these job protected and paid leave under these two scenarios. What if she needs 4 more weeks for her final round of chemo and then can return? What needs to be considered by the employer? Well, as you can see on the next slide, after FMLA exhausts, your policyholder needs to consider what other leave entitlements may apply to Carly. And one of the big ones is the ADA reasonable accommodations. And additional leave can be a reasonable accommodation in some circumstances, but not always. So it's possible that the employee has, it is reasonable to expect that employee to return to work, and it is not reasonable for them to stay out on additional leave. However, as the case law has evolved under the ADA regarding leaves as an accommodation, typically a defined relatively short-term additional time off under the ADA will be considered a reasonable accommodation. So in this case, Carly wanted 4 more weeks off after her FMLA and STD were exhausted because she has 1 more round of chemo. That typically, first you looked at, is she disabled under the ADA? And a cancer will qualify as a disability under the ADA. So is she entitled to a reasonable accommodation of that additional 4 weeks of unpaid leave? Typically, that defined period may be reasonable, but an employer still has the opportunity to reject offering that leave as an accommodation if it would impose an undue hardship on the employer. An undue hardship analysis all deals with, it's wrapped into the financial resources of the employer, whether they are capable of providing that additional 4 weeks without it costing a lot of money to hire replacements or other sorts of things that they need to consider as to whether it places an undue hardship on them to give her that additional 4 weeks off. Important to note, indefinite leave is not a reasonable accommodation. So if a medical provider comes back and says, this person needs more time off, but it's open-ended, we have no idea when they may be able to return, that in and of itself generally is not reasonable. Now, of course, what happens is then the medical providers will say, she needs 4 more weeks. And at the end of 4 more weeks, she'll say, she needs 4 more weeks. And it continues to get extended. And that becomes very difficult for an employer to deal with because at some point, that additional leave does become an undue hardship. There are also stay-at-work accommodations, though, that employers should consider. It's not just leave as an accommodation under the ADA. So there may be flexible work arrangements that they could arrange with Carly. So could she work from home on certain days, even though she's undergoing chemo? Could she do reduced schedule where she's working 4 hours and off for 4 hours, or she's off for 2 days a week and works the other 3 days? There's other types of arrangements that maybe allow her to stay employed and stay at work that would be reasonable accommodations, not place an undue hardship on the employer, and still allow Carly to get the necessary treatment, but also retain her job. Again, I just want to stress, there should never be an automatic cutoff date for ADA. You need to look at it on a case-by-case basis. So if an employer comes to you with a request to say, gosh, after 30 more days, we're cutting everybody off of ADA, that likely will be seen as a discriminatory policy. As case law has evolved, the courts are seeing that as discriminatory. Now, just because FMLA and STD exhausted, there may also be other more generous state leave laws that apply. For example, Massachusetts PFML has a 20-week employee medical leave provision. So Carly would fall within the 20 weeks that she's entitled to if she was eligible for Massachusetts PFML if she stays out that additional 4 weeks. So employers need to consider that. The other thing is company policies. Is there something in the company's programs and policies that would allow Carly to take additional time off? Remember, even though someone may be disabled, you need to treat them similarly to everyone else so that you're not discriminating on the basis of a disability. So if company policies say allow other people to take time off for a medical reason or a similar inability to work for that period of time, the employer would need to take a look at that before denying any such leave to Carly. So let's go on to number 7. We're rolling right through these. Dilemma number 7, differing notices, certifications, deadlines, appeal rights. The majority of these laws have different requirements, right? So the FMLA has eligibility and rights and responsibilities notice that have to go out within 5 business days of the employer becoming aware that an employee might need a leave that is covered under the FMLA. Certifications can depend on the leave reason, but typically under the FMLA, once the employer has decided that they are going to require a certification, whether it is for the medical condition or it is for a family member's medical condition or a family leave reason, then the FMLA regulations specify that the employer must provide at least 15 calendar days for the employee to return that completed medical certification form. There's designation notices under the FMLA, and there's no appeal right under the FMLA. If an employee feels that they have been denied FMLA unlawfully, they can either file a complaint with the Department of Labor, which is the US agency that handles the FMLA enforcement, or they can file a private lawsuit under the FMLA. Now, those are very different deadlines and requirements that may apply under, say, an STD policy. There, the policy is driven by the provisions within the policy that may provide deadlines that are different, such as a policy might provide 30 days for the employee to return a medical certification form. In addition, they likely have an appeal process, at least if it's an ERISA-covered STD policy. So if there's a denial, there's a whole appeal process that must take place. Under the ADA, if there is an obvious disability, someone's in a wheelchair and has been, it's not just a temporary thing, and that disability is obvious, employers should not even be requiring a medical certification of the disability in such cases. But they may require medical certification or support that indicates what tasks that employee can and cannot perform at work. So if there are essential functions that the employee is able to perform, but they need a reasonable accommodation, it is fair game for an employer to ask for a medical personnel, a healthcare provider, to provide more details about exactly what that employee can or cannot perform at work. In addition, under the ADA, there's no set deadlines. It's a reasonableness standard. The interactive process is what applies, so that employer is supposed to be interacting with their employee, having multiple discussions about what they can and cannot do and what possible accommodations would allow them to remain at work. And there are no set deadlines like the 15 days within the FMLA. So that can be a real challenge because you may have an employee who's facing coverage under all these types of leaves or benefits. So let's look at how do you solve that. That's a really good question, right? So the employer solutions really are there's a variety. You can either seek to draft and use company leaves and company policies, company provided benefits that use the same or similar deadlines, say as the FMLA. If employers make that kind of their standard, then they can really manage to that one set of deadlines and that one set of criteria for managing all leaves that would apply for that particular leave reason. I also recommend if an employer is going to do this leave absence management in-house, they have some sort of checklist or uniform documentation, and that should be based on the employee's reason for the leave and their location, right? Because the location is what's going to bring in the state laws that may apply to them. So without having checklists and uniform documentation, you know, it's a compliance headache to try to remember what different forms or deadlines might apply. So, you know, there should be based on an employee's own health. Here are the different leaves that would apply to employees, say in the state of New York. And here are the policies and insured benefits that apply. And here are all the deadlines that apply. Here's the documentation that we can require. And that should all be laid out if an employer is going to do it in-house to try to enhance all of their compliance with the required laws. Now, the other solutions are, you know, purchase or obtain some sort of automated tracking solution or absence software where where the employer continues to manage it in-house, but they have a solution or software solution that provides the mechanism for triggering all of the required notices and deadlines. And that can help on a compliance level. And of course, then there's outsourced absence management. So we talked about whether that's integrated with your STD program and such, or it's something that's handled just on leaves alone, or if it includes an ADA accommodation component. Those are all kind of solutions that may be offered by an absence third-party administrator and can be part of the solution that will help an employer stay compliant. But the best practice here is to reach out to the employee before any sort of before the employer misses these deadlines and misses any certifications that may be required in the notices and such, and to make sure that they're compliant with the law. Number 6, eligible, not eligible, or will be eligible. So I think a lot of us are very comfortable with figuring out whether somebody is eligible for, say, an STD benefit right at the get-go, right? Like there's going to be an eligibility requirement, they have to be an active employee, whatever the requirements are in the policy, and you make that determination, and that's, you know, they're either eligible or they're not. There's a twist in the FMLA, however, and that's something that can cause a lot of hiccups. So for example, you've got a scenario where there's an employee named Darlene, and she's been working for Crafty Foods since last September when she joined the company, and she's expecting her first child on October 1st. She wants to take 12 weeks of time off when her baby's born. Is she eligible for FMLA leave? Well, we didn't go into all the specifics, but as you probably know, that there are eligibility requirements under the FMLA. An employee needs to have worked for this employer for 12 months. They have to have worked for 1,250 hours in the period immediately, the 12-month period immediately preceding their leave. And they need to work in a location that has 50 or more employees within a 75-mile radius. So let's look at the solution here to this one. Does Darlene fit those eligibility requirements? Well, no, she doesn't on October 1st when she wants to take her leave, her bonding leave, right? Because she has not been with Crafty Foods for 12 months at that point. She started last December, it's only October, so she's worked there for, 10 months, maybe starting on 11 months. But she would not be eligible when she began on October 1st. But here's the twist under the FMLA. If she can go out on a non-FMLA leave on October 1st, say the company offers company benefits that would cover bonding, when she meets the 12-month eligibility requirement, that time that she continues to stay out of work after she meets that eligibility requirement must be designated as FMLA leave. So essentially, There are times when an employee isn't eligible at the start of leave, but they may become eligible during their leave. And employers need to be aware of that because, of course, the FMLA provides job protection. So if the employer is looking to take any sort of disciplinary action against the employee based on continued absences or not, perhaps not returning to work when they said they would, something of that nature, they need to look at the FMLA eligibility in order to determine if that is a job protected leave. Number 5. Is everybody still with me? I hope you're still with me and learning lots. So we've got 5 to go, and I'm going to try to get these all in before the end of the hour. So I know we can do it. So number 5 is pregnant employee. If she's pregnant, she must take leave, right? Well, pregnancies can create a lot of unique scenarios because a lot of multiple leave and accommodation laws apply. And STD plans typically will require, say, or offer coverage for a particular period of time before the childbirth, and then a specified time on the post-delivery period, absent any medical complications and that sort of thing. But some employers take the position that they're being somewhat protective of their pregnant employee by saying, you know what, you should take off the last 4 weeks of your pregnancy before you are due to deliver, because that's a good thing for you. That's healthy, or for safety reasons, that sort of thing. Well, as we can see on the next slide, that's not always allowed. So while employers must allow a pregnant employee to take an applicable leave that she's eligible for, you cannot compel a pregnant employee to take leave if she is in fact able to continue to perform her job with or without a reasonable accommodation. That's where both the Pregnancy Disability Act and state pregnancy accommodation laws come into play, and they prevent employers from compelling pregnant employees from taking time off when they are still able to actually do the job. Number 4 gets into workers' comp. So somebody's hurt at work, what happens now? So you got the absence dilemma that workers' comp applies to on-the-job injuries and illnesses. And you as carriers, brokers, consultants, you may also advise or talk about the integration with their STD or health insurance, or whether it gets into long-term disability, that sort of thing. But what about how that missed time for workers' comp injury counts towards FMLA or other leaves? So the solution there is, just because it's an on-the-job injury, it doesn't mean the employer can forget about other leaves. So if we look at the next slide, yes, workers' comp pays medical expenses and lost wages while that employee is out. If the employee meets the definition of an FMLA serious health condition, they're also having unpaid FMLA run concurrently. But what about state leaves? There are some state leaves, such as the Oregon Family Leave Act, which does apply to an employee's own health, that does not allow OFLA, as we call it, to run concurrently with workers' comp, with an exception. The exception is if the employee were to refuse light duty, then you can start running OFLA. But it is very unique to the specific state laws. So employers do need to be aware of where they're operating, what the state law leave laws require or prohibit when it comes to workers' comp, and whether they can count that time to decrement the state leave law entitlement as well. There's a recent court case that came out of the 11th Circuit Court of Appeals that dealt directly with this issue, where an 11-year employee, a long-term employee with a hospital system, fell at work and injured her right knee. The employer immediately filed a workers' comp claim, but they did not inform her of her FMLA rights. And instead, they required her to use sick leave until she returned to work in a light duty position, even though the employee continued to ask about, couldn't she take more time off? She did not want to return to work yet. And she wanted to use additional time rather than working light duty. The court found that after the employer terminated this employee because she had failed an essential functions test, that required her to use her knee when she returned to work, that the employer had failed to give her the option of taking job-protected FMLA leave, which she apparently, on the facts of this case, would have been entitled to. And so terminating her without giving her those FMLA notice of rights and responsibilities and allowing her to apply for that FMLA leave was in violation of the law, and the employer was held liable for that. So again, the bottom line on that, if it's workers' comp, you still need to think of all the other potential leaves that that employee may be entitled to, even though you file the workers' comp claim in a timely fashion. Number 3, concurrent versus stacking leaves. This next slide really gets to the heart of a lot of headaches for employers and policyholders. They want to know, can't we just run all the applicable leaves at the same time? Well, the answer is some do and some don't. Some run concurrently at the same time, but in other cases, employees are able to do what we call stack leaves. That is, use them consecutively, first exhausting one and then having a benefit or protection kick in under another leave law. This is an example, and it's very fact specific, so don't hold this to every scenario of a California employee who's pregnant and then has a C-section delivery. But under this scenario, we're going to assume that her doctor is going to certify that she is disabled for an 8-week period for that C-section delivery. There, as you can see, the first 4 leaves do run concurrently, which is the California state mandated SDI program. And there is an 8-week pay for a C-section. Then we're going to assume this one, the client, the employer has a private STD policy, and there's going to be an 8-week pay for the C-section under that policy as well. Then you've got California Pregnancy Disability Leave, or PDL. Because her doctor is certifying that she's actually disabled during that 8-week period under this fact scenario, then she has PDL running concurrently, which is unpaid, but is job protected. And then you have the FMLA. So that's 12 weeks of job protected, unpaid leave. And so whether she is certifying to FMLA because of her disability for the first 8 weeks, then she may go on to bonding leave for the additional 4 weeks. Now at week 8, then, when she's exhausted those first 3 leaves, now you've got California PFL that kicks in, paid family leave, where she can get up to 8 weeks of bonding leave. That does not run concurrently with the California CFRA, the CFRA, and the Family Rights Act. That then offers 12 additional weeks. So this shows that there are so many different leaves, particularly in California, some of which run concurrent, some which can be stacked, that would allow this employee under this fact scenario to take up to 20 weeks of job protected time off for this pregnancy with the C-section that caused her disability. So let's talk about solutions. How do we determine the concurrencies and the stacking leaves? The next slide shows that there can be a lot of overlap, but then there can be some cases where you can help prevent the stacking. So on the next slide, you can see the potential scenarios where leaves may be stacked. And that is because, leaves may be stacked because the law prohibits a concurrent leave. That, for example, in my example, was where this California Pregnancy Disability Leave does not run concurrently with the California Family Rights Act, or CFRA. So if the law prohibits the concurrency, they can be used. If there's a leave reason that's supported by the proper documentation, they can be used one right after the other and stacked. What if there's different eligibility rules? That's another reason where leaves end up being stacked. The PDL in California has no eligibility requirements. There's no length of service or hours requirement that pregnant employee needs to have worked for the employer in order to be entitled to up to 4 months of time off if she's disabled due to a pregnancy-related reason. The FMLA, of course, does have eligibility requirements, as we discussed. It's very possible the employee could take California PDL 4 months of unpaid but job-protected leave and then still be entitled to FMLA leave later on in the year if she then becomes eligible for FMLA leave and has a leave reason that's covered. What about different family relationships? So the FMLA, when you take, an employee takes family leave to care for a family member with a serious health condition, the FMLA defines that family member as just a child, a parent, or a spouse. A lot of the new leave laws, including the paid family and medical leave laws, are getting very expansive about covered family relationships and include additional family members such as grandparents, grandchildren, siblings, and even some are including any individual who's either related by blood or affinity, whose close association with the employee is the equivalent of a family relationship. So for example, that could be if you have a cousin who lives with the employee and they are expected to be taken care of by that employee, it's possible that could be a covered family relationship under certain state laws. And so if this employee uses that state law for that family relationship, they still have their FMLA available to use later on for a different FMLA covered reason. And that's how an employee could end up being out for a long period of time in 1 year if they're able to stack those. And finally, there are some laws, including like the Washington State paid family medical leave laws, that allow an employee to choose when to use the benefit. So the FMLA allows employers to essentially require or dictate that they designate time off that meets the FMLA leave reasons as FMLA leave. But Washington paid family leave does not allow an employer to make that designation. It is the employee who gets to choose when to use the benefits of the Washington PFML law. And so it could occur that an employee could stack benefits because they choose to use, say, company leaves first and then the Washington paid family leave. Let's get to it. Dilemma number 2, the job protection quandary. Your client's been sued because they fired an employee who had been out on FMLA and STD for severe depression. They ask for your help in figuring out what they did wrong and how they can prevent making costly mistakes in the future. Well, as you can see on the next slide, the solution is you have to look at whether the leave or benefit offers job protection, whether it offers a wage replacement on the next slide, please, or both. So some, like the FMLA or CFRA or OFLA, provide just the job protection and no pay. Others, like STD policies, typically offer wage replacement only and no job protection. Few state programs are offering both. And many, if not all of these, I don't want to say all because there might be some outlier, but most of these leave laws are going to prohibit an employer for discriminating or retaliating against an against an employee who requests or uses the leave entitlement or benefit entitlement under the program. So let's get to number 1. We're almost out of time, and dilemma number 1 is offsetting benefits. So when you have integrated multiple paid benefits, can that result in an employee receiving more than 100% of their wages? Which plays primary, which pays first? What happens when a state is really behind in processing their state program PFML claims? You might be paying STD for the first 12 weeks and the employee is not even getting pay from the state yet because they're so behind in processing. What about different elimination and waiting periods? Well, as you can see on the next slide, offsetting is something where most disability carriers on the next slide, please, will take an offset for either the estimated PFML medical benefit or the maximum PFML medical benefit. And you should look at the language of your offsetting language to determine, are you saying you're going to take the offset when an employee is eligible for the state benefit or when they receive the state benefit? Because those can be different time periods, and your plan terms should specify. In addition, employers, your policyholders need to know that their paid company policies should include language to specify that offsets will be taken from the company's paid policy to offset those state paid programs. And just a note, very recently in May, the District of Columbia enacted an emergency legislation or ordinance in that district to prohibit insurers from offsetting STD or LTD benefits based on an employee's actual or estimated District of Columbia PFL benefits. That we hope is not going to be a trend, but it is something where the council members in the district said that insurers should not be the ones who are benefiting from the state having a program and should not be able to take that offset. So that's wrapping it up right in the nick of time. The next slide tells you that, you know, absence management is a complex world. And that's why we're trying to educate you so that you know the big issues, you know the big challenges, and can help find solutions for those. So I don't know if we've got much time for any questions, but Chris, were there any questions that you think might be a quick one that we